Thanks, Monica, and thanks, Dr. Geist and Dr. Laidlaw, for a really interesting discussion about online streaming. As Monica said, I'm Julie Fashion. I'm counsel in the Dentons Litigation and Dispute Resolution Group in Vancouver and a member of Dentons National Privacy and Cybersecurity Group. And I'm pleased to introduce our next panel, Reforming Privacy Law and Fostering Innovation. So with me today are Dr. Teresa Scassa, Tim Morris, and Kelly Osaka. Teresa is at the University of Ottawa. She holds a Canada Research Chair in Information Law and Policy. She is a faculty member at the Centre for Law, Technology and Society and a full professor in the Faculty of Law Common Law section with cross-appointment to the School of Information Studies. Tim is counsel with BMO's Canadian Personal and Business Banking Group. He has experience with multiple lines of businesses and regulatory functions within the financial services sector. He's also a contributing author to the Comprehensive Guide to Legal Research, Writing, and Analysis. And Kelly is co-lead of the Dentons Litigation and Dispute Resolution Group in Calgary and a member of the Dentons Privacy and Cybersecurity Group. An experienced commercial litigator, Kelly has particular expertise in cyber breach coaching, cyber risk analysis, class action defense, and regulatory investigations. And just before we get into our discussion, a reminder that you can put questions into the Q&A box. I'm hoping to have some time at the end to pass some of your questions along to our panelists. So Kelly, we'll start with you. If you could give us the legal backdrop to our discussion with the recent and upcoming legislative changes in privacy here in Canada.
Sure, thanks, Julie. Welcome. Good morning from snowy Calgary, where it's -22 outside. So the rest of you and the rest of the country can enjoy that. I'm happy to talk about Bill C-27, also known as the Consumer Privacy Protection Act. As we heard from Monica and the previous panel, this bill was previously C-11, and that was back in 2020, but was scuttled because of the federal election. So hopefully Bill C-27 has a better trajectory going forward. It's basically a complete overhaul to our federal legislation of PIPEDA. Part 1 of Bill C-27 would enact the CPPA, and that would contain some wholly new provisions from what we saw with the original bill of Bill C-11. We know just from last week that the federal government presented the Bill C-27 for the second reading and debate in the House of Commons. And we also know that the Minister of Innovation, Science and Industry, when presenting the key provisions of Bill C-27, specifically highlighted the fact that it does contain new protections for children's privacy. So perhaps I'll start there when I'm just talking about what we can see that's new in Bill C-27. Now, I'll just start by saying that the CPPA does not define a minor or provide a specific age threshold for the application of children's personal information. So this is a departure from what we've seen in some international law, like GDPR has its age defined as 18. The new UK age appropriate design code similarly has an age definition for a minor. So this does create some ambiguity, which will make it difficult, I think, for organizations to determine what personal information, children's personal information they have actually collected and how they're using it. The default would likely be the age of majority province by province. So for example, in Alberta, that would be 18, whereas where Julie is in BC would be 19. So I guess that would give us some guidance on that issue. The other new thing with children's personal information is that it's actually defined as sensitive information. So we know that when that sensitive information title is given to personal data, it does come with heightened safeguard requirements, express consent for collection, use, and disclosure. So knowing that children's personal information is sensitive will also create these additional obligations for organizations to comply with if they are collecting that type of information. Also new is that because it is sensitive data, parents and guardians can consent on the child's behalf. However, the child can also exercise control and provide consent if it says in the bill, if they are capable of doing so. Of course, we don't also have any definition of capacity or what capable of doing so means. So this creates some ambiguity as to whether the parents are the ones consenting to the collection of this children's personal information, or if it's the child doing so. One way that an organization could potentially address this would be by creating something like age gating mechanisms, or actually defining the age to which parents or guardians need to give consent. So just moving away from children's privacy for rights for a moment and looking at the bill separately and also what's new, we have this obligation under Bill C-27 to implement privacy management programs. So that means policies, practices, and procedures that organizations will have to have ready to go once the bill is implemented. These policies are going to need to use plain language and be made readily available upon request. Also new is the fact that the service providers will have to provide a level of safeguard equivalent to that which it is transferring to another organization. So this means that we're going to have to take a look at all of these vendor management contracts, and those will need to be updated to reflect this requirement. And the bill also creates the ability for an individual to request de-identification, where an organization modifies personal information so that the individual cannot be directly identified from it. It also creates the right for requesting disposal of personal information, and with limited exceptions. So that's kind of what we're seeing with Bill C-27. The part that the litigators get excited about, of course, is the enforcement mechanism. I think we're the only ones that are excited about this. We know from the previous bill that the Privacy Commissioner would oversee compliance and make recommendations to this newly created Data Protection Tribunal regarding penalties. We also know that the penalties are going to be quite significant if implemented. So an administrative monetary penalty could be up to 3% of global revenue, or 10 million Canadian for violations. And that includes violations of all those provisions I was just talking about, such as failure to establish a privacy management program, failure to give that or ensure equivalent protection when transferring personal information, failure to adequately specify the purpose for which you're collecting this information. So there's a lot of potential risk there from a regulatory enforcement perspective. And then, of course, once you have the regulatory enforcement perspective, you also have that litigation risk, that potential class action risk that comes with it. And baked into this bill is also the private right of action when the commissioner or tribunal has made a finding that there is a statutory tort that could potentially lead to a lawsuit as well. So I won't get into the new AI and Data Act, which the previous panel had kind of touched on. I imagine Teresa has a few things to say about that as well. I do want to just touch really briefly on Bill 64 in Quebec. The first set of requirements came into force in September of this year. It was inspired by the GDPR, and just at a very high level, it does have mandatory privacy impact assessment requirements, mandatory breach reporting requirements if there's a risk of serious injury, which, Julie, I think leaves BC as the only jurisdiction that doesn't have mandatory breach notification requirements. And then it also, Bill 64 also has enhanced consent provisions and actually defines a minor as under 14 years of age, and personal information may not be collected of a minor without the consent of the parent or guardian. So those are some of the highlights from Bill 64. Alberta, we have PIPA. It's supposed to be substantially similar to the federal legislation. There hasn't really been any movement yet to do a full review and report or any sort of consultation as to how that process will take place yet, though I expect we will be seeing more information from that from the Privacy Commissioner going forward.
Thanks, Kelly. And building on that and your comment that BC is now the only jurisdiction without mandatory breach reporting. You know, we do have regular legislative reviews, regular special committee reviews of the legislation. And there's been, I'll say, noise in the privacy community in BC for a while about needing to, you know, harmonize the mandatory breach requirement, mandatory breach reporting, otherwise bring, you know, our 20-year-old legislation in step with technology today. And, most recently, that's last December, the special committee recommended more or less those things. Um, but those same, let's stay caught up recommendations have been made before with the prior special committees. And we just don't seem to have the political interest in making the legislative changes. I mean, we do have a new premier. Maybe it'll happen. I'm sure it'll come eventually. At some point, BC will have to catch up. But who knows when that's going to happen. But thanks for that overview, Kelly. I hope that can kind of frame our discussion for the rest of the questions. And Tim, I'm going to turn to you now from the private sector perspective. Can you talk a little bit about how you see privacy and the changes in regulation playing into the process of innovation?
Sure, I am happy to do that. And so we're all lawyers in the room, or not all, but I will preface, and I think this will come as no surprise, that I'll just add the disclaimer that my views are my own and they don't necessarily reflect is a timely discussion. I really do think we are sort of in this age of digital transformation. People want things to be done efficiently. They want things to be done easily, with minimal interruptions to their day. And really sort of companies in the private sector need to focus on sort of meeting people where they are right now in all the services they provide. And so companies now are faced with the challenge of trying to innovate and provide these sort of streamlined services to their customers. But those innovations really do need to be balanced against certain necessary functions and within the requisite regulatory frameworks that we're talking about. And so the challenge and the work isn't just the innovation, but it's also balancing that innovation and implementation against what your regulatory obligations may be. And so what that means practically is when there is an idea or whether there's a particular innovation for a new product, any kind of new development, there are lots of sort of things I'll say kind of like floating around. And I think that's really sort of like where legal comes in. And as you know, in my role as in-house counsel, where we really do sort of begin to provide that value to the business. And so normally you're brought into on the outset of a project and you begin mapping out sort of some of what these legal and regulatory considerations may be for any particular innovation. Sometimes you find yourself in a situation that is going to be a bit more straightforward and settled, and then you just have your sort of checklist of we'll go through A through I, and we know if we can satisfy all these things we'll be on side and everything's good. Other times you find yourself in territory that's a bit more uncharted, and that's where I think things can kind of get sort of interesting and fun. And I think one example of this sort of uncharted but very, very fun area of innovation in the technology and digital space is BMO's development of a Twitch channel. And so those who are sort of unanointed, Twitch is a streaming service owned by Amazon, and it primarily was for gaming and now has since expanded into something much larger where people stream games, art, real life, all of these things. No other bank, as confirmed by Twitch, in the world was doing this. And so this was an opportunity for the bank to say, well, let's develop a presence and move into and innovate a new way of approaching customers. There was no playbook for that. No bank had ever done it. And when the group came to us, I was very excited. I'm a gamer. I love Twitch. I've used it. I've streamed on Twitch, and so I was very excited. But then you also have to take a step back and say, okay, well, what are we going to do? Like, how do we do this in a way so that we're on side all of the various requirements that we need to be on side of? And so that's where you sort of begin to sort of loop in groups like privacy, for example, to say, this is the plan, right? This is what we want to do. Here is how we think we're going to do it. And this is what we want to do to sort of create value along the way. And what are your thoughts? What are your concerns? And sometimes when there isn't that kind of playbook, you sort of need to look at what the landscape is and really try to apply it and sort of think, how could this play out? Like, what are the things that we need to think about? And, do we need to go sort of above and beyond what might be I'll say the baseline requirement? Is there something else we should be turning our mind to? Almost need to think ahead a little bit to think, well, how could we do this? How will this be interpreted? And what, we want to make sure that we're giving the best presence and service to the customer, but we also need to make sure everyone is going to be protected. And so I think that, that's always going to be the challenge, right? Is going to be saying that this is the innovation, but we need to make sure that we are going to be on side of whatever regulation or legislative framework is there. And really, it's bringing together, at least in sort of the in-house world, bringing all the stakeholders together to have that conversation, particularly when you're in these like new innovative projects or ideas that won't necessarily have a roadmap. And as we move forward with the development in these areas, it's not always going to be as straightforward. And so I think there's lots that can be done, and I think that's just going to be the balance for private sectors, is to say, we might not always have this like playbook that we can go from, because we've changed and because we've come so far. Legislation may be very old; it won't always necessarily reflect the current reality. So what do we do to not only innovate by way of product and service delivery, but how we sort of balance those new things in this sort of new legislative world?
Thanks, Tim. Teresa, turning over to you, and some of this may overlap with the end of the last panel that we heard, but now that we have the AI Act coming, now that we have AI specific legislation coming, can you discuss some of what you see as the potential impacts or the potential difficulties of what's been proposed so far on innovation in the AI world in particular? Sorry, I'm not sure if it's just me, but I can't actually hear you, Teresa. I don't know if
Yeah, we can't hear.
Andrew, as our tech support, I'm not sure if you can assist there.
Hi there, Teresa. Can you hear me? Do you want to just go down to the little arrow beside your microphone and make sure that it is set to most likely your computer microphone?
Does it
I
work?
still can't hear you.
Can you hear me now?
I can now, yes. Thank you
Yeah,
very much.
Okay, I'm sorry
Thanks.
about that. So I got to be the person today who has the Zoom issues. Wow, I feel so privileged. Okay, so sorry. Now I've just closed my window. Okay, let me get going then. Sorry. So I was just saying that when Chantal opened this conference, she framed it the themes of the conference around tensions and some of the tensions that we're experiencing in this context. And so I thought I would shape my comments around the idea of tensions. And so when it comes to the AI and Data Act, which I'll call the ADA, there are, I think, a number of tensions that are evident there. And the first one that I'd flag is speed versus public engagement. Because with ADA, I think what we see is a desire on the part of the government to get this thing through quickly. We did not see this wasn't part of Bill C-11 in the last go round. It's newly added. There has been no public consultation on ADA. There has been, very, very little opportunity for any kind of engagement around this bill. In the minister's comments on the bill when it went to second reading, he talked about how Canada will be the first or among the first to actually enact legislation of this kind. And so it feels like it's some kind of race. And speed is this overarching value. And yet what is left to the side with that kind of speed is public engagement. And so, as I mentioned, there hasn't been any public consultation on this. The response of the government, I think, has tended to be, well, so much of the bill is left to development and regulations, not necessarily a good thing, that there'll be an opportunity for consultation as the regulations are developed. And all I can say to that is that the regulation processes are more remote for ordinary individuals and not necessarily the best place in which to have public engagement around issues of AI regulation. And if you compare it to the EU's AI Act, of course, not only did they have considerable public engagement before the draft was made available, but there has been ongoing debate and discussion of the draft. And so there's, by comparison, there's just so much more consultation and engagement around the EU AI Act than we're seeing with this portion of Bill C-27. The other thing about leaving the consultation to the regulation making process is that nonetheless, in passing this bill, we are going to bake in a framework that itself received no consultation. And so there are certain elements of this framework that will simply be there and choices that are made already on which there is going to be little consultation. To just pick up on a point made by Emily Laidlaw on the previous panel, we have to be asking ourselves how this bit of AI regulation fits in with so many other pieces that are relevant to AI regulation, from regulating online harms to medical device regulation and so on. And how does this fit in? And we haven't had that conversation or discussion. So I think that that's an important first tension with this bill, which is this tension between speed and public engagement. Another tension that I think is interesting, and I haven't heard a lot of discussion about it, are the federal provincial tensions, the jurisdictional tensions with this bill. And I have been trying to dig into them and pull them apart, because I think there's some things going on here, certainly that I don't fully understand in terms of the constitutional dimensions of this bill, but it refers to the regulation of international and interprovincial trade and commerce in artificial intelligence systems in the purposes section, clearly invoking the general trade and commerce power as a basis for jurisdiction. And yet a substantial part of this bill addresses the design and development stages of AI. So many of the obligations relate to the design and development stage. And that design and development stage is often entirely intra-provincial, not always, but in many cases, for example, development that takes place in universities, in hospitals, and many hospitals or workers within hospitals are involved in developing AI systems, researchers, small startups, and so on. You have intra-provincial design and development in a bill that is focusing on interprovincial and international trade and commerce, and yet so you've got obligations that apply before you have that kind of movement. And so to me, there's a question is what's going on there. There's also the broader general trade and commerce issue, and please forgive me for talking about the Constitution and the technology panel. I think everybody in Canada has a little bit of constitutional anxiety syndrome when it comes to talking about jurisdiction. But, for general trade and commerce, the Supreme Court has been clear that you can't use the general trade and commerce power to govern, to regulate a specific industry. And it raises the question is AI an industry, or is it a broader phenomenon? And I think the government has been very careful not to refer to it as the AI industry, but many people do. And so there's this question as well in terms of that general trade and commerce power. I note as well, if you look at section 3, sub 3 of the bill, provincial departments and agencies can be excluded from the application of this bill by regulation, which I think is just odd and interesting as well. So I think there's some constitutional issues here that need to be aired, that haven't been aired in terms of how this bill is supposed to work. And rather than just be the person who raises the constitutional issues and says, yeah, we have to think about the Constitution, I actually think this poses the further question, which is, what is the role of the federal government in this space? What should the federal government be doing with respect to AI regulation? Is their role to pass this type of legislation? Is their role more to facilitate and convene consensus, federal and provincial consensus with the private sector around what proper AI governance should look like? And here I'm thinking of the NIST framework that is developed at the federal level in the United States, which has received a lot of consultation and input and has been refined and developed and could be a framework that is adopted more broadly for governance of AI systems. So that's the second tension I'd identify, the federal provincial tension. There's also just the broader tensions that you find in legislation of this kind as to what to leave in and what to leave out. there are some interesting things going on, I think, in this bill. For example, anonymized data was left out of the CPPA part, is excluded from scope of CPPA specifically. We pick up anonymized data again in ADA, although there's no definition, and it should have incorporated the definition from CPPA, it didn't, but there is no definition of anonymized data. And I think this is meant to resolve a governance gap for anonymized data that we're reassured that it'll be dealt with here. Although there I would flag that the only anonymized data that will be governed by ADA will be in relation to high impact systems, which are, it's not a defined term, that's also left to regulation. It won't apply to uses of anonymized data by the list of actors that are excluded from the application of ADA, which is most of the federal government, DND, CSIS, CSE, and so on. So I just flagged that issue around anonymized data. Harm, I think, is an interesting issue in this bill. The focus in terms of the definition of harm, the focus is on individuals and not on groups. It should, in my view, be on both. And I think it's very clear that we're moving to this broader concept or broader understanding of the harms that can be caused by AI and how they may not just simply be individual harms, but also group harms. And yet we don't see that reflected in this legislation. There is a reference to biased output. And so the response might be, yeah, but if it's just, if the harm is kind of discrimination more broadly, it'll be captured by biased output. But bias is not the only potential group harm from AI. The definition that's adopted of biased output focuses also on individuals. And the terms harm and biased output are used sometimes separately in the bill, with only harm and not biased output as a trigger for some ministerial actions in the bill. So again, I think that there's stuff that needs to be worked out there. If only we had consultation and discussion prior to it being introduced, we might have been able to raise and address some of these issues. The huge knowledge and resources gaps between public and industry seem to also call out for independent governance and oversight. And that's something that we don't really see in this bill. And a fourth tension I'd raise would be governance versus agility. I think it's a false tension. You can have both. Agile doesn't have to mean kind of frantic and last minute. It's not supposed to mean that in any event. But this bill, I think, is very weak on governance. Oversight is by the same ministry responsible for supporting and developing the AI industry in Canada. There isn't an independent regulator, and we've also got features, for example, where audits are privately commissioned, where an audit is required. Again, there's no independent regulator or auditor, and that brings me to the fifth tension, which is trust versus lack of trust. And I think there's a huge trust gap generally when it comes to technology in our society, and other speakers have made reference to some of the trust issues that we have had recently. And so I think that the lack of engagement with this bill certainly doesn't help with the trust issues, but it also manifests itself in other in other features of this bill. So if you look at the blanket exclusions for the Department of National Defense, CSE, and CSIS, the bill says it doesn't apply to any product, service, or activity under the direction or control of those agencies, which seems to mean that anything they do is exempt from this kind of governance or regulation. So there are no AI no-go zones as we see in the EU AI Act, or specific limitations. And in the EU AI Act, for example, with respect to the military, the exception is only for military applications as opposed to all potential uses by the military of AI. And so you only have to think of, for example, the publicity over the domestic PSYOPs experiment by DND in Nova Scotia to think that, maybe it would be a good idea to have a narrower carve-out exception here as an element of trust building with respect to government and AI. So I've done that really quickly, just trying to give you an overall arching view of some of the themes that I think and tensions that that arise in this bill, which we've had so little time to debate and discuss and chew over publicly. The messaging from the government seems to be that this is going through. It's been added into Bill C-27, I think, as part of that, and that there's no appetite to slow down and take longer on it. And I think that that is unfortunate.
Teresa, I think that raises some real issues from an innovation perspective and from a private organization's perspective, especially the issues around compliance with a regulation that's not, or a law that's not well defined, as you point out, and has some extraterritorial jurisdiction issues. That puts a lot on the organization in terms of trying to figure out how it will comply and what the risks are for non-compliance. And I just note that in the bill, the penalties for non-compliance are quite significant as well. It could be up to $10 million Canadian, or 3% of gross global revenues for non-compliance. And then you talked about harm too. And if there is serious physical or psychological harm through the use of the AI system, it could be a fine of Canadian 25 million, or 5% of gross global revenues. So the penalties we're talking about are quite significant. A lot of these organizations, or many of these organizations who are trying to be compliant with the statute, will most likely be smaller startup organizations. So you also have to think about this from a cost perspective and overhead perspective as to how much this is going to eat into potentially their profits as well.
Yeah, I think that there's a lot of uncertainty, and I see the uncertainty as a problem from a public perspective, but it's also a problem from an industry perspective as well. With so many of the issues being left to regulation, it's really hard going into this to really understand what this bill is about, what is actually going to cover, what's being left to some other bill or some other context like online harms regulation. What the carve-outs are going to be. There's also the challenge that I didn't mention, that with regulation making, first of all, it's slow. So we've got this shell of a bill now that will be filled out by regulations, but how long is it going to take for those regulations, and which ones are going to be prioritized, and which ones will never ever get drafted? Because we've seen that before too with, Castle's private right of action is still waiting on regulations to become a thing. And so it just, so these are also, I think, issues and challenges with this particular bill. It almost feels as if you pass the bill and then you can check the box that says we did something about AI regulation, but there's the real work is still to come, and it's not clear when or how that's going to get done, or what the content of that will be.
Thanks, Teresa and Kelly. And Teresa, I'll just say, you are not the only one having Zoom disappeared for a little while. Am I gone again?
No, we can hear you.
Okay. I am not sure what's happening with my Zoom today. I have sent Kelly my in case I somehow get dropped again, because I'm not.
Oh.
I'm really sorry about this, everyone. I'm going to try to get the next question in, and hopefully I will not disappear again. This one's for all three of you, and kind of building, Teresa, on the tensions theme. There can be an additional tension between what the regulatory standards are or are going to be, and public perception of what standards should be, what is, I guess, more broadly appropriate in the privacy sphere. And I was hoping the three of you could comment on that particular tension and how it plays into innovation, risk analysis, reputational considerations, those sorts of issues. And if no one's going to go first, oh, go ahead, Kelly.
Well, I was just going to say, I think that there can be definitely a gap between where the regulation is, especially in Canada, where we've sort of lagged behind what's gone on internationally in Europe and US and elsewhere. So their public perception of where the regulation actually is in Canada can actually be quite far apart from where the regulation itself is. And I think Tim already mentioned this when he was talking about the Twitch channel and implementing that, and knowing that perhaps that the Canadian regulation was going to change, but those changes not actually having been implemented. When I talk to my clients about, what are the best practices from a compliance perspective, you're probably looking at the highest threshold that there is, whether that's GDPR or the UK or California, because we know that the regulation is eventually going to get caught up there. Or you might have jurisdictional issues where you have users outside of Canada who are using your product or service, and you may get captured by those other laws that are held to a higher standard. So there definitely is a tension there from an organization's perspective as to where they should be from a compliance perspective.
Yeah, and Kelly, if I can pick up on that, I think that's quite right. And you see this sort of in the and again from the in-house world, is that you do have sort of the regulatory expectation and the obligation put onto the organization. But that's not sort of where the conversation ends. Specifically if we're discussing a new innovation or something that we might want to do, we sort of will use that as the guiding and say, this is sort of the groundwork that we have. So this is what we need to do. But then it's, well, how would this play out in the court of public opinion or from a public perspective? And is it enough? And I think that, I think increasingly we're finding that customers and consumers are, they're more tuned in, they are more savvy. And so where you have these sort of regimes that are kind of lagging behind in some instances, like it's just not good enough in some cases, right? And so part of the challenge, I think, and I think companies can do this well, is anticipating, well, what would a consumer say about this particular practice, particularly if it's based on, a regulation that is a little bit more dated? Would they expect more, even if the current black letter, be honest about that? Because if not, I think that, it's not enough to say like, well, yes, we were on side of this particular regulation. One of the risks for any corporation or company in the private sector is the reputational risk, and that isn't always going to be tied to, did company A comply or not. It's going to be, well, how did that impact somebody, and what was the risk to the customer, and what was the harm to the customer? And you really do need to be able to sort of take a step back when you're innovating and developing and say, well, we know what we need to do, but how do we take that further? How can we build on that to make sure that the best interests of our clients are going to be sort of considered and maintained throughout this? So it is a difficult sort of difficult but achievable kind of conversation to have, of balancing the regulatory obligation, whether it's in its current state or what you think it might course of action or the other.
Yeah, and so I'll just jump in because I think those are really important points. And I when I was thinking about this question, I was thinking about a particular example that got an awful lot of media attention recently, and that led to a parliamentary ethics committee hearings, which was the PHAC mobility data issue, right? Where you had the Public Health Agency of Canada using mobility data that it sourced from 2 private sector companies for analytics purposes during the pandemic. And that just blew up in the media and caused this big public outcry. And so in that context, you had, if you look at the parliamentary committee hearings, it's not as if there was an obvious or flagrant breach of any of the laws that we had in place. And in fact, the private sector companies had created these mechanisms that were in compliance with the law, the existing laws, to share data for public, and in TELUS's case, data for a good platform that had been, you know, certified and accredited and all of these sorts of things. And yet you had this scandal that erupted around it, and which has significant reputational impacts for companies that have in good faith engaged in, you know, compliant activities. And I think some of the takeaways from that experience, well, first of all, there were many recommendations that were made by the Ethics Committee with respect to amending legislation, the legislation we have, which goes to Kelly's point that our laws are out of date and they're not addressing the context or the situation or the ways in which people use data, the needs that people have for data. And so the laws need to be updated, and that work hasn't been done. And this bill is only going to do a small part of that. We still have the Privacy Act, the Federal Privacy Act to deal with, and other legislation as well. So there's one of the issues is out-of-date laws, but the other issue goes to a point that was made by Chris Parsons earlier this morning, which is that transparency is becoming so much more of an important element. And I think that that theme runs through that particular instance and the at the hearing report as well, which is this idea that there wasn't, people didn't know what was going on or what was being done, and the means that were chosen to convey that information to people were not effective means. People had apparently consented to their data being used in this particular way, but that was not a realistic consent, and I think Chris Parsons talked about this as well. It wasn't a realistic consent. So how do we create a context in which people have a much better understanding, where there's much better transparency or knowledge about how data are being used and for what purposes, and the responsibility there falls on both public and private sector actors. And so I think that's an important question to have, and a really important piece of this puzzle in terms of ensuring that the public expectations match the legally compliant practices that or activities that organizations are engaged in. And I have to say that's partly at the root of my frustration with ADA is this lack of transparency and lack of public engagement. It's hard to tell what this bill is about with all of its moving pieces, and there's been no public conversation about it. And you know, I think that's a really bad start, if I can say that enough times here. I think that's a really bad start to governance in this space.
Yeah, in the PHEC blow up after the fact, the criticism of the government and of the organizations, even though they had been compliant and did get the requisite consents, was basically that they took advantage of outdated privacy laws in terms of what they were collecting, how it was used, and for what purpose, without, as you said, Teresa, transparency. And I think that's what it comes back to. It's this need to be in constant conversation, if you're an organization, with your customer base to figure out where they're at in terms of what their expectations are on transparency. Another thing that comes to mind on this issue is the UK age appropriate design code. So this is going back to children's privacy rights, and one of the standards actually being that yes, these products and services that are directed to youth will have parental monitoring provisions in them, so allow parents to see what their kids are up to. But the flip side of that is that they also recommend that the children be made aware of the fact that they are being monitored by their parents, so there isn't this sort of unknown monitoring that's going on. So anyways, it you know, it comes back to, like we said, transparency and what the expectations are from customers.
And speaking as a litigator, and my camera's off now because I'm advised that gives me a better chance of actually staying here with everyone. But speaking as a litigator, it'll also be interesting to see how that spools out in class action litigation, since we're starting to see, you know, that there is some divergence between what is a breach of the legislation and what is actionable harm, at least in some contexts. And it'll be interesting to see if that starts to spool out in litigation as well. And as a litigator, of course, as Kelly mentioned, you know, the part that we are most excited about in the Act is the changes, the litigation changes, the new tribunal, the drastically increased penalties, the new federal private right of action. And so I'm hoping the three of you can comment a little bit on how you see that impacting innovation?
Well, I can start with that. I mean, I think we have to look overseas again to see how these penalties, these large penalties, have been implemented and what effect, if any, that's had on private organizations. We had a recent example with the Irish Data Protection Commission fining Instagram, or Meta as the parent company, as the controller in question for 405 million euros, and that was for multiple violations of GDPR. Meta is appealing that decision. But the two types of violations that fine was meted out for was basically that children's contact information, including phone numbers and emails, were automatically being made public when they switched from a regular account to a business account. And then the other piece of it was that there was public by default on these children accounts that they were creating, which was in violation of the GDPR as well. So basically, there was this finding that there was a failure to provide an explanation during the registration process in plain language about what the difference between public and private accounts actually means, and the fact that the accounts were public by default and it was not provided for in the data policy. So during the course of this investigation, and I've been involved in these regulatory investigations before, and they're very lengthy typically. So there is a lot of opportunity to sort of address these issues during the course, even before the final findings come out. And then that's what happened in this case. So Instagram went ahead and gave children users the option to choose between a private or public account as opposed to making it public by default. And then they also created the option to refuse the publication of their contact details as part of the design of the program. So I guess I'm just pointing to this as an example of where we have these fines, we have these large fines, and of course regulators always like to go after the big juicy targets, these big social media platforms, to make a point out of them. But we do see some changed behavior as a result of these investigations. I guess my concern with these large penalties and this compliance risk is not so much with those large social media platforms, it's with the smaller to medium-sized businesses, which will also be obliged to comply with these new laws. And specifically from a data breach perspective, when a medium-sized business experiences a data breach, it's very, very harmful to the business, and from a cost perspective, from a customer relationship perspective, and just trying to revive itself afterwards is quite difficult. Having regulatory risk for other provisions, such as not having a privacy platform or privacy program management in place, just creates more compliance issues for these small to medium-sized businesses, which will then have to pay for someone to come in and assist them with that as well. So I do think it adds to overhead and just creates more risk and uncertainty for organizations.
There's something, if I can jump in on in here, is one of the things that I think is really interesting, or that I'm kind of tracking and following, relates to just the way in which the federal commissioner and the provincial commissioners that have private sector data protection jurisdiction have been increasingly cooperating. And we've seen that over the last little while, where they have more and more joint investigations into large data breaches. And these are joint investigations where I think there's increasingly an assertion of concurrent jurisdiction. And not just overlapping jurisdiction. And so what I think is going to be really interesting is to see what happens post CPPA, once we have the CPPA in place. Quebec already has the power to administer significant administrative monetary penalties. If BC and Alberta amend their laws to be substantially similar to the CPPA, they may also introduce AMPs, significant AMPs. So we've moved from a soft enforcement environment where the commissioners have collaborated and cooperated in an attempt to sort of harmonize interpretation and application of data protection laws across the country, to one in which, if they continue to do this, you're going to have interesting situations where you might have multiple AMPs, for example, being imposed by different commissioners in relation to the same breach, where you also have a federal privacy commissioner who now has had his interpretive authority shifted to the data tribunal, right? So the findings, not just orders, but findings of the commissioner can be appealed to the data tribunal. And so they may be, doing joint investigations and coming up with joint conclusions, but with respect to the federal commissioner, those might be overridden by the data tribunal, which has an impact on that cooperation and collaboration. So I think that we're going to see some changes in practice or some impacts on practice that maybe we haven't fully thought through yet in terms of how these different issues are going to be handled. And I think that will be something that will be very interesting to watch.
Thanks, Teresa. Tim, did you want to add anything on there?
Well, I would just add that, I think it is something that, will be consideration, though I think that from my perspective, I don't know that it will necessarily hamper the innovation of an institution like BMO, for example. We always strive to be the very best business partner that we can with any regulator. And so and because we are a heavily regulated industry, we have lots of practice about that or around that. And I think that, you establish the regulatory framework, and the way that I always kind of imagine it is a bit of a back and forth, right? Is that, you get this sort of idea of what needs to happen, and oftentimes it's not too prescriptive as so it doesn't become too stale too quickly. And then there's going to be a private sector sort of interpretation of what that looks like and how that plays out. And I do think that, in this sort of de facto kind of way, there's this kind of like mutual development of here's what was said, here's how it actually works out in practice. And then that sort of, I'll say, like gains momentum over time, and you see that the development of that and sort of new ideas and new trends sort of develop from that. And I think you kind of see that, in, I don't want to call them adjacent, but in new regulations, for example, like the Consumer Protection Framework, you get this idea of that was born out of a development in certain trends, and now we see this sort of in a similar kind of way. And I think that in a lot of ways, banks, for example, they can look at, well, what did we learn from that? What did we learn from the development of CA6 into the Consumer Protection Framework? And what can we now do for, like, can we take some of that learning and see how this would apply to a new regime that's coming forward? And I think we can do that. And I think that we do that well. And so there we have this sort of resources and expertise internally to look at, well, here's the new landscape, here's the new world that we're operating in, and we can deploy that in the expectations in a way that doesn't hamper innovation, and we're still able to move forward.
Yeah, thanks. And building on that and some of Kelly's comments, and this is perhaps trite, but how new regulations, how increased, what I'm going to call increased litigation risk as a litigator, is going to impact will impact different industries differently depending on their risk appetite, and will impact different organizations depending in part on their size and sophistication. As Kelly put it, it is the compliance burden on smaller organizations that aren't as used to complying as BMO is going to be different in nature and bigger. And also, again, speaking as a litigator and a class action defense lawyer who thinks about these things, there's a couple things that strike me with this. One, and related to Kelly's point about that, organizations are already starting to deal with this in the issue in the regulatory process. But with the private right of action not being triggered until there's a tribunal decision, that could be a really long period for defendants to be at risk of litigation, effectively a really long limitation period. And it'll be interesting to see how that plays out, and whether plaintiffs' counsel wait to plead it until the time has run, or whether they preemptively plead it to get in there and get carriage of the action before somebody else does. And there's also some increased complications that I see coming in class actions, partly because we're adding another cause of action, and we already see we see the torts, the common law torts pleaded for Ontario. We see BC's Privacy Act cause of action pleaded. Now we're going to have another cause of action to deal with. And, as Teresa was just saying, also a potential for a divergence in underlying facts as found by, say, the BC Privacy Commissioner in a joint investigation, and then the tribunal. And that's going to make it's going to make it much more interesting for us litigators, much more fun. But for organizations, potentially much more challenging and much riskier. We just have a couple of minutes left. And I'm not seeing any questions, so perhaps we can close with this. We know, as has been already discussed today, the federal bills just gone through second reading. Do any of you have any thoughts coming out of that on what we might see and what impacts that might have? Teresa, in particular, in relation to ADA?
Yeah, I think the messaging was pretty clear around ADA, which is that being first is somehow like all that matters, and so that this is going through, and I think I think that's problematic messaging with respect to a bill that has a lot of issues and that hasn't had full and proper debate, as I've said. So I was disappointed by that messaging. I also think the minister is overselling children's privacy, and I know Kelly talked about what's in there and what's not with respect to children's privacy, but that's been pulled out as whenever there's difficult legislation, I think children always get invoked, is because everybody likes children. And we have to protect children. So I think we're seeing children being brought out as this is why we have to do this, and there's just not that much. I think it's kind of overselling what C-27 does with respect to children's privacy.
Yeah, I agree. I think that was just a talking point, really, to sort of sell the bill. But it looks like it's going ahead probably in 2023, barring another federal election.
Okay, well, unless there's any further comments, we may give people a minute or two additional break time. So thanks, Teresa, Tim, and Kelly, for your insightful thoughts today, and thanks to everyone who's spoken so far this morning. This wraps up our first session, or for those of you on Eastern time, the morning session. We'll now take a break. That's lunch for those of you on Eastern time, and what I'll call a mid-morning break for, say, Kelly and me in Alberta and BC. But please come back in half an hour at 12:30 p.m. Eastern time. We do have a great lineup of topics after the break. And immediately after the break is our keynote address by our Privacy Commissioner, Philippe Dufresne. So see you all in a bit. Thanks.